Perfect. Thank you. Okay. Hello, everyone, and welcome to the Future of Technology in Law, Future of Law in Technology and Governance virtual seminar series presented by the Center for Governance and Markets at the University of Pittsburgh. I am the host and moderator. I am Mike Madison. I am a law professor at the University of Pittsburgh School of Law, and my primary job today is to introduce our presenters. My colleague at the University of Pittsburgh, Jane Wynn, who has a permanent faculty appointment at the University of Washington, but currently occupies an office down the hall from me here in Pittsburgh, and her colleague and co-author, founder and executive director of the World Privacy Forum, Pam Dixon. And Jane and Pam are going to talk us through their work right now, using information privacy standards to build governance and markets, which is the title that everyone can see on the slides. So that's it from me for now. I'll be back in about 30 minutes, give or take, and we'll have some interesting conversation following the initial presentation. Jane and Pam, over to you.
Okay, so I'll start and then hand it off to Pam when it's her slide. Okay. There we go. Okay, so this is an overview of the whole presentation. So in the technology industry, people have a saying, standards build markets. So we're applying that basic insight to the problem of information governance. So we just want to make sure everybody's on board for the definitions we're going to use for government markets, governance, and then governance markets is not a common term. We're actually using that to mean regulatory competition when there's competition between governments and governance. So, and then, you know, we just acknowledge that there are competing definitions of information privacy or the interest that's being protected by data protection laws. That is a controversial subject. And then we're going to look at 4 case studies of governance design. 2 of them involve the Food and Drug Administration, which I would think the Food and Drug Administration gets a lot of bad press. And so I would think most Americans would not put them high on their list of like high functioning government agencies. But in this particular context, Pam and I are actually going to say they're doing like way better than the information privacy people. So, and then we've got 2 information privacy case studies that are similar to the FDA examples. And then we're going to say, okay, is this a valid analogy? We're suggesting that insights from food safety governance can be transferred to information governance. And we're using the phrase, like I said, market, to suggest that the basic insight of regulatory competition is that people who develop normative orders compete to attract people to join their normative orders. And so we're thinking of like how attractive these regimes are. And then finally, so we tentatively conclude that the FDA is like way ahead of the information privacy people, and suggest that maybe the information privacy people might want to take a few lessons from the FDA. So that's the overview. Okay, now the phrase standards build markets, I have actually tried to look up, like there's no authoritative source for that, but people say it all the time in the tech industry. So what does it mean to build a market? Clayton Christensen, he published The Innovator's Dilemma in the 1990s, like 25 years ago. And he recently passed away, but a decade ago, he published an article in the Harvard Business Review about why so many companies in the United States are sitting on huge hoards of cash. And so that's the capitalist dilemma, is how to invest all of their financial resources created by the easy money policies of central banks. And in that article, he talks about market creating opportunities or market creating innovations. So he says, well, where is a market creating innovation likely to arise? He said, well, here's a heuristic. If there's something that only the skilled or the rich have access to and everybody wants it, you should assume that innovation that takes place in that area would be profitable. So people will build a market. So the limit of the idea that producers want to create new markets is they don't want their core competency, their core value proposition to be commodified and standardized. They want the market to be standardized to lower transaction costs while they still retain control over, what they think of as their core competence. So now, if you study standards, so I study cross-border trade, in the WTO, and in that context, you can see very clearly, what does standardization accomplish? It reduces production costs for sellers. It reduces discovery costs for buyers because there's less variety. So that might be a bad thing, but lower discovery costs is good. Standardization does tend to lower prices for consumers by removing barriers to comparison shopping and creating market pressure on sellers to bring their prices down. It reduces information asymmetries between buyers and sellers because you basically defined what the transaction is about. And initially coming into compliance with the standard might be hard, but over the long term, it tends to reduce recurring compliance costs. So net standardization, when it's feasible, when it's possible, generally produces large social welfare gains, right? Now, there's lots of different kinds of standards, and obviously, if we're only going to talk for 30 minutes and we're going to focus on information privacy, we can't go into this very much. But in trade law, there's something called a technical regulation, which is a command and control mandatory standard. Or you could have like de jure standards from ISO. They're recognized as coming from an official organization. Or de facto would be, Microsoft Windows is a de facto standard. There's standards for weights and measures. In trade law, we distinguish between performance standards and design standards. Engineers distinguish product and process standards. So a process standard would be like how you electroplate something, and a product standard would be, how much lead is in, baby food. Okay. Interoperability standards create networks, so there's a big academic literature on that. And then finally, system standards is things like total quality management, ISO 9000, ISO 14000 in environmental law, ISO 27000 in computer security. So system standards are where the organization adopts a new way of problem solving. And in the United States, our de jure standard system is called ANSI, American National Standards Institute. And standard setting bodies can join ANSI if they want. They have to agree to certain, baseline principles. Or if they don't want to agree to that, they form something that's not recognized by ANSI. And people in industry call those consortia. So those are like informal standard setting. Bluetooth, the Bluetooth standard for near field, wireless communications is a good example of a consortium standard. That Bluetooth is just about as open and transparent as an ANSI standards body, but it has not applied to be recognized by ANSI. So there's lots of ways you can analyze standards. And what we're going to focus on here is, in the second example, we're going to focus on system standards. So in the standard setting world, when people focus on the essential fairness of the procedures that were used to develop the standard, if a standard setting process is deemed to be fundamentally fair, then in the United States, we call it a voluntary consensus standard. So back in the 1970s, ANSI began publishing a document, it's been revised, called ANSI Essential Requirements, which are basically due process for standard setting, because in the 1990s, the FTC was coming after them for antitrust violations. And so they needed to formalize their procedures to make sure that they could justify not being prosecuted for antitrust violation. But every country around the world that's involved in standard setting has some similar notion. And in the WTO technical barriers to trade agreement, they actually, as an annex to the treaty, they have a code of good practice, which has all the points from the ANSI essential requirements, and they have a couple of more as well. Now, you shouldn't finalize a standard that's not effective at solving the problem or relevant, and the drafting of the standard should be coherent. So in the United States, we sort of think the free market will take care of that. It's like people are too busy to write irrelevant standards usually. Anyway, so that's why we don't address them in America. We think the market takes care of that. Now, in addition, it's been official US government policy since 1995 that anytime the federal government does something and the private sector has already developed voluntary consensus standards that have the same goal, the government should not duplicate the work of the private sector. They should just piggyback on the private sector's work, because that's going to be more likely efficient for the government. So for some voluntary consensus standards, they just get dropped into the CFR. So the standard, if anybody has a dry erase marker, it's ASTM, I can't remember the number, ASTM 4286 or something, for non-toxic. The Consumer Product Safety Commission dropped the voluntary consensus standard into the CFR. So that's now a federal regulation. In addition, the Office of Management and Budget says that, the Food and Drug Administration, the first example is recognition that compliance with regulatory requirements, evidence of that can be provided with independent third-party proof of conformity assessment to certain specific voluntary consensus standards. So that doesn't drop the standards into the CFR. That's the people writing the standard don't like that, because that means they can't charge a fee for it. And then they're also, voluntary consensus standards are widely used in procurement by the federal government to try and keep the cost of procurement down. So we're focusing on voluntary consensus standards. And so the reason that we think the production of voluntary consensus standard is a governance system in sort of the Eleanor Ostrom sense is because people working on standards do have very clearly defined and very publicly adhered to norms for the fundamental fairness of the process. Okay, so just to get some definitional matters out of the way, let's go ahead and agree. Government refers to like what nation states do. They have a territory, they have a legal system, they have like a unified, monetary system. And in the modern liberal conception of the government, a government and a market are kind of complements. So if something is a market, it's not the government. Or you could say, markets are in the Oliver Williamson spectrum between markets, relationships, and hierarchies. Now, the concept of governance is foundational to Eleanor Ostrom's work. And so I'm assuming that some people here may have some feedback for us on those dimensions of what we're talking about. I found this definition of governance. Michael McGinnis is a member of the Ostrom workshop, so I understand there's probably 100 different definitions. That just happens to be one that I was able to find relatively quickly. So that's what we're saying. It's like governance, there's no implication that it has to be a territorial nation state. Now, the concept of regulatory competition was first identified by the economist Charles Thibault, and he just pointed out that territorial governments use their legal system to compete for mobile assets, to get people to move mobile resources across borders. So the concept of regulatory competition is well recognized. In the United States, states compete against each other, between countries, countries compete against each other to attract economic resources. So we're proposing for this talk that we think of governance markets as a social field where governments and governance organizations compete. Okay, so because governance is broad enough to include both, whereas government clearly doesn't include governance. Okay, so we're just using governance markets to be a field where that regulatory competition is happening. Okay, so I'm not going to read this, obviously. I've broken the rule on PowerPoint about how much legislation. So I'll turn this over to Pam, because Pam is the subject matter expert, and she'll just have to work with my slide.
Okay, so I'm here. I have no idea how to make myself appear on video. So someone somewhere will have to work magic to do that. So Jane, what would you like me to talk about? Just how most privacy law looks and how something else might look?
Well, I think at this point, we're just letting, in case there's anybody who doesn't follow information privacy, that there's many ways to think about privacy, but there's a rights-based approach in the US and a rights-based approach in Europe.
Okay. Yeah. Okay. So in general, when various jurisdictions and countries and legislators think about privacy, there has been a very lengthy approach that has diverged to a very great degree. So in Europe, for example, this is really where you can find the right-based approach. You can see this extremely clearly in the General Data Protection Regulation, usually called the GDPR, where you really see privacy and privacy law talking about privacy as a fundamental human right. And from the idea of privacy being a human right flows a great deal of pedagogy and philosophy and theory about privacy. And it's actually quite meaningful. So, for example, the right of erasure is something that grew out of the European context in after approximately 2010 and eventually made it into the GDPR. The right of erasure means that individuals within the European Union, if they, in certain circumstances, can have information that was published or posted online about them erased. This is very much a rights-based approach. However, if you look at the United States, what you see is a risk-based approach. And it's really possible to look at quite a few pieces of legislation in this regard. So, for example, the Fair Credit Reporting Act of 1970 takes a risk-based approach. It says basically in summary, okay, so we have credit reporting agencies that are bringing in all of this data, this credit data and risk data about people, how they spend, if they've defaulted on a loan, do they make their payments on time? And all of this can be quantified. And so instead of saying, oh, well, this is just okay, because of the various problems that were being found by the public and Congress, the risk-based approach basically said, in order to reduce the risk of the credit reporting agencies collecting this huge amount of data that has meaningful consequences about people's eligibility for credit, we're going to go ahead and we're going to say, okay, so let's make sure that we are providing government oversight over the algorithms and how they work. Are these fair algorithms? So the government gave themselves the possibility, because of the risk of unsupervised algorithms in this case, they gave themselves the ability to supervise these particular algorithms for example, for credit scoring.
Okay,
and
so
you can
Pam?
see how that flows. Yeah.
Yeah, shall we go on to the next slide? That was a quick
Absolutely.
explanation. Okay, so here, do you want to talk about this? The FDA recognition of consensus standards.
Yeah, these are the VCS. I'll give a very brief summation of this. So the federal, so, and Jane, we can do this together. Quite some time ago, during the Clinton-Gore administration, there was a whole process to try to modernize and make government more efficient. And one of the inefficient areas was the Food and Drug Administration. They were taking years and years to pass standards to regulate medical devices. Medical devices are very important. They have the potential. New medical devices can save lives. For example, heart pumps and pacemakers and things like this. So the idea was to move good products through the pipeline faster. And to do that, they focused on standards. So instead of using the older and more lengthy ANSI process, they moved to voluntary consensus standards. And voluntary consensus standards, Jane had mentioned these and put a slide up about what these look like. They are they require certain items to be in place. It is not self-regulation. The standards require openness, a balance of interests, due process, an appeals process, and also a rough consensus. It's general agreement, but not necessarily unanimity. And the thing is that this sped up approval, and you can go on the FDA right now, and Jane's put the link in. You can literally see a database of thousands of recognized standards for each standard relates to one medical device. It's fantastic.
Actually, I don't think it does,
Jane?
Pam. I think that's actually not quite right. I think what it is if you go through the medical device pre-approval process, you might have to, you negotiate with the FDA and you might have to demonstrate like 217 things. And if there are voluntary consensus standards that address like 37 of those, then you pull those 37 requirements out. And what you're left with is the 180 that you have to prove fact by fact. So the voluntary
Correct.
consensus standards just fill in part of the facts. Okay?
Right. And it's very helpful. Yeah. And so what you can see,
Shall
you
we
can
go on to
literally
the next
pull
slide?
the
I'm worried.
standards.
Yeah, so I'm worried we're going to go way over the 30 minutes. So that's why I'm trying to
We're okay.
advance the slides. Okay, so would you like to do this one, Pam?
Just very, very briefly. So most privacy law flows from so privacy law in the early days, from the 1970s to approximately the 1990s, flowed from a more risk-based strategy. But in the 1990s, the European Union passed European Private Data Privacy Directive, EU 9546, which was the predecessor to the GDPR. And after that point, you really saw a lot of human rights-based policies, as well as policies that followed what's called the fair information practices. And post 2018, you really see this on steroids. You see a lot of kind of GDPR-like regulation in the US and elsewhere. As of today, 157 countries have passed some form or another of GDPR. So the big issue right now in the United States is, what will a federal law look like, and what does state law look like in regards to an overarching privacy approach? So the Uniform Law Commission took this up and came up with the UPDPA, the Uniform Personal Data Protection Act. And it's very unique because what it does is it says, okay, here are certain things that everyone must do. And it basically, if you are following what would be expected and are having a relationship with the consumer that follows along expected norms, fine. But if you do something where a consumer might need to provide consent, then you need to create a voluntary consensus standard if you want to have a safe harbor for that. And so there's a couple of sections in the UPDPA which makes quite novel use of this. And I think it would have created more cooperation between stakeholders, and perhaps may have led to some very, very good best practices. This law was introduced in several states, but did not move.
Yeah, and so this one is an experiment. So basically they took the FDA quote unquote recognition. So the private sector's already produced the standard, and the regulator looks at the standard and says, with regard to certain facts, you can establish that those facts are the case by having an independent third party do conformity assessment. So they made that possible under the Uniform Personal Data Protection Act, but so far it's not law yet, and it hasn't been around long enough for anybody to do the standard setting. So it's a possibility. Okay, so now I'll do the next couple. Okay, so the United States Food and Drug Administration has been collaborating with industry, both in the United States and in countries that export food to the United States, to get everyone on board for best practices, because they figured out decades ago that they would never be able to hire enough employees to do command and control inspections. They realized early on that they needed collaboration with all the various stakeholders. So the first thing they did was they took the HACCP standard, Hazard Analysis and Critical Control Points, which was a food safety standard developed by NASA and Pillsbury so that the astronauts would not get food poisoning while they were in outer space. And the Food and Drug Administration has been trying to find ways to motivate food producers to voluntarily adopt HACCP. So HACCP is a system standard. It's like ISO 9000 or Six Sigma. So you can't force anyone to do it. You can invite someone to do it, but they have to engage their critical thinking capacity to make it work. So the FDA has been doing kind of like light touch regulation. on a risk-adjusted basis. So the first 4 industries that were required to comply with HACCP were seafood, juice, meat, and poultry, because those had the greatest risk. And they also developed a food code that they keep updating in light of best practice, to serve as a model for, state and local governments doing, food inspection, and for industry. In 2011, after a lot of scares about tainted food, the Food Safety Modernization Act gave the Food and Drug Administration much, much broader powers. But they have continued to adopt this collaborative approach, and they've been handing out, for a decade now, they've been handing out grants to state and local government to carry out, projects to improve compliance in their jurisdiction. And then they've aggregated that into, standards of excellence for continuous improvement across the whole food safety industry. And in 2019, the FDA issued this policy document called the New Era of Smarter Food Safety. And so I was skimming over that, and I noticed they said, we need food traceability to be able to perform root cause analysis. So if anybody knows how continuous improvement works, when something is not working, you're supposed to perform root cause analysis. So when the FDA regulators talk about collaborating with industry and other regulators at state, local, territorial, and tribal governments, they actually use the language of quality management the same as in the private sector, and they appear to be actually doing what they're saying. So after a decade of collaborating with state, local, tribal, territorial regulators and industry, in November 2022, they issued the food traceability rule, and it's going to, compliance will start in 2026, and that will actually allow them to track food from farm to fork. So they've ended up at this absolutely phenomenal outcome in the public interest, and they have not used command and control, because safety culture is not something that you can force people to do. By contrast, if we look at the Federal Trade Commission, anyone who's looked at any of the Federal Trade Commission consent orders, it should jump out at you that these are continuous improvement orders. So because you can't force someone to do continuous improvement. It's like you can't force someone to believe in a particular religious faith. You can't force someone to fall in love with someone. You can force them to conform their conduct to a standard, but you can't actually control what they think and feel, right? So the FTC has quote unquote consent orders, right? And it's like, query how consensual they are. But when they discover that someone is engaged in unfair and deceptive trade practices involving the misuse of personal information, the FTC's preferred method is to negotiate, and they have hundreds of these posted on their website. They've been doing this since like 1997. And every single one of them requires continuous improvement. And then once you've implemented continuous improvement, every 2 years, you bring in an independent third party, conformity assessment process. So the Federal Trade Commission is definitely moving in the same direction as the Food and Drug Administration. They're both moving towards continuous improvement and collaboration. But if you compare how the FDA collaborated, they had grants that people could apply for so they could learn to do better, right? And the Food and Drug and the FTC brings enforcement actions. So it's not clear to me just how collaborative the people involved feel this really is, right? So we can also see that if we look back here, the Food and Drug Administration issued this document called A New Era of Smarter Food Safety, and they explained how they had implemented continuous improvement, at the FDA and with all the other stakeholders. There's no such roadmap for the FTC. It's very fragmented. It's very indirect. So they have a similar impulse, but it's not as coherent. Okay, so this is the big picture question for the research paper is, does it make sense to use these voluntary consensus examples from Food and Drug Administration food safety law as possible sources of inspiration for information governance? And we've seen with the Uniform Personal Data Protection Act they very explicitly copied the FDA's process of quote unquote recognizing a standard that's come bottom up from the private sector. So the standard setting process in the American private sector is competitive. ANSI facilitates standard setting, it doesn't control it. So using voluntary consensus standards in this way would be a governance market, using our definition. So there's competing governance institutions, which are different standard setting organizations. But when we shift over to the system standard, a system standard is not something where you can send a tangible object to a third-party lab to test. Somebody has to come in and evaluate like the culture and processes of the institution. So it's much more ambiguous to evaluate. And the Food and Drug Administration is actually using science-based risk assessment. You know, they're tracking the incidence of disease. And so they actually have pretty good hard scientific data, and they can show that continuous improvement adopted in a collaborative way does actually improve public health over time. Now, the Federal Trade Commission is doing isolated pieces. They don't have any ability to do science-based risk management because they don't have the data they need, because they don't have the mandate that the FTA does, right? So the information privacy process in the United States is very fragmented. We also see governance competition in that context, but it's not producing big dividends for citizens, for the public. Okay, so before I go to the conclusion, Pam, did you want to say anything about sort of the comparison between food safety and information privacy?
Yeah, basically it's a different approach if you really think about it. So food safety is inviting a lot of collaborative work, and what they're doing is they're overseeing the work that has been done and providing very, very high level guidance, but it's collaborative guidance. But if you look at information privacy or information data governance and privacy, what you're seeing instead is that there's basically there in the United States, there's two essential enforcement mechanisms: the Federal Trade Commission at the federal level, as well as agency, for example, in the sectors, the Health and Human Services will do health-related compliance, and then you have, you know, the SEC doing, you know, financial sector compliance, et cetera, et cetera. But if you look at the FTC and the AGs, the Attorney Generals, it's quite fragmented. You don't see a continuous loop of improvement. You also see very fragmented interest areas where there's compliance. And so it's quite a different approach. Whereas at the FDA, you can really trace what they're looking at, why, and you can look at the measurement. And it's the measurement that really makes a very significant difference over time.
Okay, so here's the conclusion. Okay, so does anybody recognize the quote? If you want knowledge, you must take part in the practice of changing reality. That's Chairman Mao on Practice, 1937, a noted pragmatist. That's a joke. Okay, so what our analysis would tend to suggest is that the rights-based approach, although it cloaks itself in the rhetoric of individual liberty, is actually a front for top-down command and control efforts run by bureaucrats. So jurisdictions that have that kind of top-down command and control regulation, it is taxation by regulation, and it does hobble the industries in those countries because of the high cost of compliance. And we would dispute that you can apply like private property notions associated with the rise of liberal governments, you know, and the Enlightenment with the flow of information. We would suggest the flow of information is not something that's amenable to a private property rights analogy. So system standards are a process, and the formal written text of system standards like HACCP are voluntary consensus standards, and they can, because they're the output of a collaborative problem-solving process, which is voluntary consensus standards. It's actually easier for organizations to implement them, and they actually produce better outcomes with less waste. So the United States used to know how to do system standards in information privacy, and then we had like a huge collective memory lapse. And so Pam and I are sort of hoping that we'll remember what we used to know back in the 70s. So that's the conclusion.
All right.
That's a great
wow.
conclusion.
So much stuff. I have 1,000 questions and comments, but let me lean back and ask if Zekia, Aditi, Jean, if you had anything that you wanted to lead off with in terms of reactions to this. Reflecting still. Okay, so while you all think, let me offer a couple of quick things. Jane and Pam, I will probably write up a much longer set of comments and questions for you and send them to you later on. Let me just have 2 quick observations. One is I love the overall insight. I love the case studies and the detail at the back end. I think the front end has a lot of moving parts and a lot of detail, and I want to kind of sort of distill its essence to kind of sharpen and make more powerful what you're really arguing. So let me make 2 quick observations in that regard and see what you think. One is I'm not thrilled with the competition metaphor, right? The idea that there is a kind of governance competition. I understand how you're kind of using that to kind of pull in some other history and some other scholarship, but it's not clear to me exactly what kind of what the competition consists of and how framing it as a competition sort of helps your overall argument. And kind of related to that, and Jane, particularly towards the end, when you were getting towards the conclusion, when you're referring to how these different kinds of systems either do or do not clearly improve public health, or do or do not clearly improve the lives or well-being of individuals. You're sort of activating a thought about evaluation or assessment, meaning relative to any kind of government or governance or market-derived strategies. How is it that we, and I'll put the we in the air quotes to signify that exactly who the we is in this question is never completely clear. How are we to evaluate whether one strategy is better than a different strategy? How are we to evaluate whether your framing of this whole thing is better than a different framing? So one framing that might come to mind is, well, you've just described a series of public-private partnerships, and there's an exhaustive literature on the structure of public-private partnerships, and you've simply talked through some specific instances of public-private partnerships. I take it that you're not just talking about public-private partnerships, although public-private partnerships are one element of some of these cases that you've described. So my sort of general question is, how do these governance phenomena exist either in contrast with or in complement with other kinds of governmental or market-based systems? How do you know whether one approach is better than another?
Can I jump in here super quickly? I'm going to answer a piece of what you're asking. One of the issues, and we didn't really talk about it here, but first off, thank you for your comments. I think they're astute. One of the issues in especially information privacy and data governance is that we don't have good measurement of compliance, not just in this country, but in others. We measure so many things in other areas, including food safety. There's a measure for that. But when we ask, okay, how effective is the consumer financial, the California, the new California privacy law? How successful is it? How successful is the new Virginia privacy law? How successful could even proposed legislation be? There's not been an appetite for measurement, and this is certainly one of the problems. I have some more thoughts, but I'm going to pause and let Jean jump.
Okay, yeah. So So Mike, what I would say is, when I graduated from college in 1980, so you can do the math and work out how old I am, there was this huge cloud over, the economy and the political system of the United States, because that was when everybody thought Germany and Japan were going to overtake the United States. And so there was all this soul searching about, did we need a national industrial policy? Did we need to change labor management relations? Did the government need to subsidize different things? And, when I talk to my students today, they literally have no idea that there was that long period of existential doubt where it looked like the United States was in terminal decline. So one of the things that made the difference, of course, is the rise of the internet, and the fact that the internet exploded out of American society and spread around the world, not the other way around. So in the world of standards and networks, whoever defines the network only has to learn one thing, but everybody who didn't define the network has to learn how to get along on the network in addition to what they already knew, right? So we had that huge subsidy. And when you look at how the United States maintained its lead as the global hub for innovation in information technology and a bunch of other stuff, it is actually the competition between different governance institutions. So ANSI represents the more established standard setting organizations. So IEEE is competing head on with Bluetooth. Now, in most countries, like the United Kingdom, they have the British Standards Institute. They have a few other standard setting bodies, but nothing like the United States. The United States has literally 1,000 standard setting organizations, and they're all out there competing with each other. So the basic insight that we're building on here is that there's something about Anglo-Saxon cultures, because the UK does have other standard setting organizations besides the British Standards Institute, and the openness to having like governmental recognition of standards as establishing facts for regulatory compliance purposes. That's something that, because it's more decentralized and fact oriented and analogy oriented, not hierarchical theoretical. When you look at countries like Germany has DIN, Deutsches Institut of Normalization, France has China has one organization. Almost every other country in the world only has one standard setting organization. Now, the idea is that the private sector people will show up at this government facilitated organization. Most of them are not directly controlled by the government. They're quasi-governmental. So basically our idea is that the governance of technology standards might actually be a better way to understand the normative framework within which real progress could be made in protecting what's important about information privacy. So that was a very long answer, but it's like basically, if you're not familiar with how ANSI works and you're not familiar with the competition between ANSI and the consortia, then it would be kind of hard. Then I agree. It would seem like we're making a lot of very unfounded claims.
Oh, no. So make sure I'm clear. I'm not suggesting you're making a lot of unfounded claims. I think from an intuitive standpoint, I understand a lot of what you say, and I'm agreeing a lot with an enormous amount of it. I'm just trying to draw out, particularly at the end of your answer there, kind of the sharp end of your stick, right? Which are, there are these different, we'll call them sort of different regulatory modalities that exist at different scales, right? They exist at a very, very large sort of nation state transnational scale, right? I remember the mid 80s and the panic over Japan and all of that. But it also, in a kind of Ostromian kind of polycentric sense, it scales all the way down. And the closer down to the ground level you get, the more the kind of collaborative governance phenomena in many contexts stands out in contrast to a more top-down dirigiste kind of modality. The paradox, and it's really a kind of a rhetorical paradox as much as it's a conceptual paradox, is that standards production in your description is optimized in this collaborative, collectivized sort of governance framework, and then you align that, which is a very much a Lynn Ostrom style commonsy, if not specifically a commons kind of phenomenon. You align that with competition, which is rhetorically and conceptually associated with the dynamics of markets. And so what you're doing both rhetorically and conceptually is you're sort of harmonizing at different levels. So that's not like they're simply butting together simultaneously, but the idea of standards competition takes a commonsy kind of governance model and puts it directly into alignment with a kind of market dynamic.
And I've actually been a member of standard setting organizations. What happens at standard setting organizations is competition. It's a framework within which people can compete and remain civil. It's not.
Yeah, and I'm going to add.
Yeah.
Yeah, I'm going to add to that thought. You mentioned in your query public-private partnerships, and the thing about public-private partnerships is it usually means public sector and business. But with the voluntary consensus standards, we're really talking about a true collaboration between a lot of different players in the ecosystem. You're talking about the standards organizations as well as civil society, as well as business, as well as public sector, as well as academia and research institutions, including public interest research institutions. And they have to play by fair rules. There are requirements within this kind of a governance process that are more Ostronian, where you're looking at the ecosystem and saying, okay, how can all of the participants in the ecosystem play fair with each other, all have a voice, et cetera. It's a little bit more formalized, but it's essentially that.
Yeah. So in a sense, a voluntary consensus standard is similar to a price in a competitive market system. It's a momentary equilibrium that's been achieved with great difficulty. It's a document that tells people what to do, but it actually embodies, the competition of different stakeholder positions and different stakeholder ideas.
Yes, so in my head, just to tie together what we're all talking about in different respects, and then I see Jean has a comment in the chat that I want to read out and get your thoughts on. In the Ostrom world, in kind of the native Ostrom world, governance is a set of collaboration and coordination strategies and conflict resolution strategies relative to some resource, right? The resource might be trees or fish, the resource might be information or data. In your context here, governance itself is kind of the resource. You've got, right, a kind of a cooperatively produced thing in an abstract sense, where it is the rules and norms themselves which are documented and expressed, which is an interesting thing, and I think it's worth, in some respect, pointing that out to kind of align the conceptual framework.
That's Thibault, right?
Yeah.
That was his insight. Yeah. But the other thing I was going to say is, and then we'll turn to Jean's question. The other thing I was going to say is, part of the reason I feel confident that governance is a thing that around which you can organize competition is during the medieval period, the jurisdiction to resolve disputes was an incident of feudal tenure, the same as the corvée. So it was an attribute of someone who was hierarchically superior in the feudal social hierarchy. So it was just looked on as a thing that they owned. Jurisdiction was a thing that was owned. So that's a blind spot that people in the modern era have. And I would say it's because there's a lot of God talk about rule of law. That's sort of the downside of the Enlightenment, in my personal opinion. But now let's turn to the question, if you don't mind, let's turn to the question that Jean asked.
Yeah, so let me read this out for the benefit of the recording, and thanks to Jean. Isn't there a top-down dynamic in information governance systems dominated by the risk-based ethos as well? The same is true for voluntary consensus models. Efficiency gains mask profound information asymmetries, embedded capability advantages, and the illusion of neutrality or situational fairness.
So
Can I respond to that?
okay.
Oh, just take a first swipe. So this is a very common articulation of how this works. However, if you read Ostrom and you think of the information ecosystem as a very complex data ecosystem and knowledge ecosystem, one that can be that has many participants and many aspects of interest. There are many interests in this ecosystem. And in our current era, the default understanding of this ecosystem is to look at it as deeply asymmetrical. And that is the entire point of ensuring that there is a due process that allows and facilitates a fair and multi-stakeholder model. So the multilateral organizations such as the UN and the OECD in particular, and to some degree the World Health Organization, they all have these models that are a little more top down, and they're quite collaborative. They don't leave anyone out unless the participant is extraordinarily bad behaving, and even then it's difficult to leave them out. So I do think that there are a lot of misunderstandings, but the idea, the entire idea behind this is that there is much more parity involved with a voluntary consensus process. And it's not all risk-based today. There's a huge blend of processes and articulations of how governance works. There's many, many governance tools other than risk evaluation.
Yeah, so I was going to say, sorry, I went over to get my my marker here. It says ASTM D4236. So, oops, where's the camera? There you go, camera. We can't quite get it. But if you have a dry erase marker, it says conforms to. ASTM is a voluntary consensus standards organization, and the Consumer Product Safety Council would not have incorporated their standard by reference into the Code of Federal Regulations if they had not been satisfied that all stakeholders were present. So the lawyers in particular find it really hard to believe that without coercive mechanisms controlled by lawyers, that stakeholders representing different perspectives in society can come together and engage in like a fair, well-informed dialogue and produce a deliverable. But that's what ANSI is in charge of. So now, why doesn't Bluetooth qualify as an ANSI accredited standards body? Because if we went down that list, there would be one or two things on that list that Bluetooth doesn't feel they can agree to, and so they don't get ANSI accredited. No one has to be ANSI accredited if they don't want to. And so, you know, you can have a proprietary technology that becomes a de facto standard. No one is required to participate in voluntary consensus standards, and not all voluntary consensus standards achieve the same level of success in the marketplace. But if it's like, you know, if legislation goes through a vigorous process of democratic debate, then the ensuing legislation is much more likely to be appropriate to the situation. If it's produced in, you know, smoke-filled, you know, back offices and then rushed out, like, for example, the pension legislation in France, which is causing months of demonstrations on the street, I mean, then, you know, it's going to trigger social controversy. So part of it is, I think, it's outside of engineers. Very few people actually understand how voluntary consensus standards work. And engineers have very few professional incentives to write social science articles explaining how democratic the process is. Andrew Russell is a historian of technology who did publish a very good book on the history of standards and why they have these internal checks and balances that are not visible to people who aren't engineers. The other thing I was going to say was, there's a huge controversy about the difference between like how you define risk and how you define uncertainty. So uncertainty can't be modeled because you don't know what you don't know. Risk is something that's amenable to sort of like data analysis. So I think one of the advantages of allowing voluntary consensus standards to bring together diverse stakeholder groups to debate issues is before you can get to having like statistical models of risk, there has to be an awful lot of empirical discovery. And having diverse stakeholders participate in the standard setting process allows things that might not be visible to government regulators or lawyers to be taken into consideration. And I think part of the reason that Pam and I are suggesting that the continuous improvement model, which is a feedback loop, that was invented by Walter Schuhart, who worked at Bell Labs in the 1920s, and it was the foundation for Edwards Deming and total quality management and the Toyota way. And as far as I can tell, so as a business law professor, I've been studying risk and uncertainty and appropriate institutional responses. As far as I can tell, there literally is no way to process uncertainty outside of a continuous improvement process, because you're continually discovering and adapting in light of new facts. So I think when I read Jean's comment, I thought that it was very much a definition of risk, in the same sense that insurance companies can create actuarial tables where you have a defined problem and a defined data set. But the voluntary consensus standard process, because it is more porous, it can accommodate, you know, the ability to recognize where there's uncertainty and to begin to test on an experimental basis different responses to uncertainty. So decision-making uncertainty is a more difficult problem than statistics. So anyway.
Okay, so
And I have one very, may I add one brief but
ahead,
very
yeah.
important thought, which is a very great use of the voluntary consensus standards is to fill in gaps that emerge in the market. So for example, under the EU GDPR, national statistical organizations are exempted from the GDPR because they're doing statistical research for that particular member state. So a voluntary consensus process is being undergone right now at the National Statistical Commission to fill that gap, because they want guidance and they want rules, but they're making them together with a lot of other parties. So I think that it's just a very good way also to fill gaps where regulation has unintendedly, left openings that may be a problem. Thank you.
Thanks, Pam. So let me give, Jean has one last quick question in the chat, and we'll get to this and then we'll wrap up. Jean asks, what about the adoption of default rules in voluntary consensus models? How sticky are default rules in voluntary consensus environments? And maybe Jane, if you want to repeat what you put in the chat.
Yeah, okay. So I don't think you can answer that in the abstract. You can't answer how default rules work in law in the abstract. You need a particular factual context and a doctrinal area. One of the hallmarks of voluntary consensus standards is that the organizations retain continuing jurisdiction. So how long has Bluetooth been around? Bluetooth has been around 30 years. How long has IEEE been around? IEEE has been around like 100 years. Okay, so these organizations, if industry feels that the defaults have been set wrong, they come back and they update the standards. So these are living organizations producing living documents. And if the standard drifts out of touch with reality, the transaction costs of adjusting a voluntary consensus standard are much, much lower than the cost of getting legislation through with division of powers in the federal government. So it's actually a more organic, dynamic, evolving form of norm than anything that we have in the legal system. It's much more flexible than even the common law case law system.
Okay, thank you, Jane. So I'm just going to very, very quickly punctuate a couple of things that I was hearing, and I'm going to keep coming back to, and I'll correspond with both of you after the fact. One is I loved all the references to QA and the whole field of quality assurance and quality assurance engineering, which is something that I've got a connection to from a family standpoint. I love the empiricism of all of this, and I love the comparative institutional analysis that's really at the core of what you're talking about. So there's an enormously rich field of research and payoffs that are associated with all of this. So I have to call this to a close because we're a little bit past the top of the hour. Jane and Pam, thank you so much for being here and for sharing your work and for being so timely and provocative with your thoughts.
And thank you to you, Michael, and to Jean for the great questions.
Yep. And
thank you. Thank you all.
And thank you everybody for being here. Aditi, I think we can go ahead and turn off the recording. Thank you all so much.
All right. Thank you, Professor.